be speaking on the broader issues that the International Court of Justice raised in its advisory opinion, namely, before it was able to reach the opinion that the war was illegal, the International Court had to lay out some fundamental principles of international law on the basis of which they reached their opinion. And I'll be speaking in those fundamental principles. I want to begin with a quote I came across while reading somebody somewhat far afield, namely Gandhi. I was reading through his collected works, which are quite substantial. They run to 90 hefty volumes, 500 pages each. And I was reading through them, and I came across this remark of his. He said, all compromise is based on give and take, but there can be no give and take on fundamentals. Any compromise on fundamentals is a surrender, for it is all give and no take. The time for compromise can only come when both sides are of one mind on fundamentals. Well, the obvious question that quote begs is, what are these fundamentals on which there can be no compromise? And my own opinion, for what it's worth, is that in the current world, the only standard available is the standard of international law. Those are the fundamentals on which, to quote Gandhi, there can be no compromise. You might say 20 years ago, when I was still a student, or even 30 years ago, you could say there was a competing set of fundamental principles. At that time it was called some version of Marxism, sometimes Marxism-Leninism. But you can say, I think fairly, that as it were, a subversive version of fundamental principles has now, for better or for worse, is been effaced, and what we're left with, again, for better or for worse, is international law. That's the only available standard to judge the fundamental principles on which there can be no compromise. And I will argue in the time that's allotted me that there's a remarkable consensus on the fundamentals for resolving the Israel-Palestine conflict, and that Israel is the main obstacle to a resolution of the conflict on the basis of these fundamentals. Let me begin with a remark by Jimmy Carter in his last book, or penultimate book, I think he's written another since. In Palestine, Peace on Apartheid, he said, Israel's continued control and colonization of Palestinian land has been the primary obstacle to a comprehensive peace agreement. Peace will come to Israel and the Middle East only when the Israeli government is willing to comply with international law by accepting its legal borders. That was considered something of a controversial opinion when Mr. Carter articulated his book. In fact, it's not so controversial as it may seem for those who are familiar with the scholarly literature in the Israel-Palestine conflict. There was a very noted leading scholar in international law, a fellow by the name of Quincy Wright, who I checked with Professor Dugard, and he knew him. And already in 1970, so we're talking about some 40 years ago, already in 1970, Quincy Wright wrote, in view of the acceptance in principle of the Resolution 242 by the adjacent Arab states except Syria, the major obstacle to progress seems to be the refusal of Israel to do so and to agree to withdraw from occupied territories. Well, it sounds very much like Carter, but as I said, it was 40 years ago. Well, a reasonable question which many of you may think, not necessarily having studied the law, would be, why should Israel have to withdraw? Other countries acquire territory by war. Why shouldn't Israel be allowed to? Or the other version of that argument In 1967, Israel fought a war of self-defense, and shouldn't or aren't countries allowed to acquire territory in the course of a war of self-defense? Those arguments are fairly well known, and then the only thing that we can do is look at the historical record, what happened in 1967, and then look at the legal record on this principle of acquiring territory by war. The historical record on what happened in June 1967 is still somewhat murky, but certain points are pretty clear, or I would say at this point they're entirely clear. Neither Israeli nor U.S. officials believe that Israel faced an imminent threat to its existence when it launched its first strike on June 5th, 1967. In my opinion, and I'll be happy to go through the documentary record, that's a clear and unequivocal point. We know it for very good reasons. At the end of May 1967, when the war seemed imminent, or a clash seemed imminent between Israel and the neighboring Arab states, in particular Egypt and Syria, but also Jordan, U.S. Intelligence agencies went back over and over again, checking two questions. Would Egypt attack? And if it attacked, what would happen to Israel? And over again, our intelligence agencies, about 6 different intelligence agencies, checked. And over again, they reached the same conclusions. Number 1, Egypt wouldn't attack. And number 2, if they did attack, to quote the then President Lyndon Johnson, if they did get attacked, you're going to whip the hell out of them. Well, that's the American opinion. What was the Israeli opinion? Well, we know for sure what the Israeli opinion was, because on June 1st, the head of Israeli internal security, the head of the Mossad, Major General Meir Amit, was in Washington. And when he was asked, what's the opinion of the Israelis on what's going to happen, he replied, now I'm quoting him exactly, there were no differences between the U.S. and the Israelis on the military intelligence picture or its interpretation. There were no differences. What was the U.S. opinion? There was going to be no attack, and if it did happen, Israel would whip the hell out of them. And complete agreement between the Israelis and the Americans. So there's no argument whatsoever, exactly zero, you could say. There's no argument whatsoever that Israel fought a war of self-defense in June 1967. It was a first strike. It was not a preemptive attack. If you turn immediately after the June 67 war, the 5th emergency session of the UN General Assembly met in order to discuss the outcome of the war. The member states of the General Assembly, the member states were divided between those holding Israel responsible for the war, those holding both sides responsible for the war, those saying it's impossible to tell who was responsible, and then there were those countries which just didn't comment. The only country in the world, literally, the only country in the world that maintained Israel had acted in self-defense against Egyptian aggression was Israel. That was not the opinion incidentally of the United States. The American opinion, as expressed by Arthur Goldberg, who was the UN representative at the time, was that both sides bore responsibility for the outbreak of hostilities. Well, some of you may not agree with my reading of the record. Fine. Let's, for the sake of argument, say Israel did engage in a war of self-defense. If it did engage in this war of self-defense, does that then give it the right to keep the territory it acquired? And here we have a fairly lengthy record of legal opinion on the topic, or at least leading authorities speaking on it. Among the leading authorities, for those of you who follow the field, would surely have been, back then, Brownlee, Jennings, and Bowick.